Hi, welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. Today, we are talking about the third question in our four-part series. What can we do with property? And we are talking about who can use property according to zoning rules. So much of what I have to say today derives from an article I wrote in 2020 called Zoning for Families, which is available for free download on SSRN. So zoning. So let's get back to the basics of zoning. Zoning is the public regulation of the use of land, structures on that land, and lots, as we've discussed in other videos. So you might not be surprised that zoning codes regulate industrial uses or skyscrapers or setbacks, but you might be surprised to learn that zoning codes almost always define who makes up a family. The reason they define family is to determine how many people can live in a housing unit. Almost always, a zoning code will say that a household unit is limited to a family, that a housing unit as well, dwelling unit. There's lots of different terms that zoning codes use to define units of housing. Family is usually defined to be a single person or two or more people who are related by some combination of blood, marriage, adoption, custodianship, or guardianship. Sometimes a family is defined in zoning to include unrelated people, and that's where my article and this video focuses. It seems clear that someone with legal bonds like marriage or blood relationships should be considered part of a family. But how clear is it that people who are unrelated are not a family? There may well be situations where unrelated people can constitute the functional equivalent of a family. The question of what makes a functional family has arisen in the law in a variety of contexts: immigration, health insurance, eviction, trusts and estates. Of course, it has also arisen in the areas of marriage rights, custody, and divorce law, all of which have evolved in recent years to encompass broad definitions of family. If you want to learn more about all of those topics, consider reading the work of Martha Minow, perhaps one of the most prominent scholars who have focused on the question of the functional family. The definition of family in zoning law, however, has been somewhat understudied. Yet we do have several United States Supreme Court cases that have grappled with this issue. So let's consider the village of Belle Terre versus Boraas. This 1974 decision dealt with a group of college students displaying absolutely no familial characteristics. As you might predict, the Supreme Court upheld the application of a restrictive definition of family to exclude those students from a zone that required there to be one family for one unit of housing. But consider a case 3 years later, Moore versus the city of East Cleveland. In that case, family was read more expansively, and consider who the plaintiffs were in thinking about why. The plaintiffs were a grandmother who sought to live with her two grandchildren who were cousins. She had received a citation from the city saying the second grandchild was a zoning violation. By the way, she was Black, might question why this particular ordinance was enforced upon her. The Supreme Court held in a closed decision that the zoning ordinance violated substantive due process because it was overly intrusive on the family and did not have a rational basis. Between these two cases, you see a theme emerging. When a group of people is truly acting as a family, as was the case in the East Cleveland matter, a court will be more lenient. When a group of people is more like a set of college students, a court will not necessarily treat them as the functional equivalent of the family. This theme, if you will, has been demonstrated by a series of Supreme Court decisions, including New York Supreme Court, which have rejected definitions of family when they are applied to exclude groups of people who truly are functional families. These courts have been making their decisions primarily pursuant to rational basis review which is required in challenges rooted in due process. In my article, I argue that many of these newer decisions about zoning as it applies to families are sound, especially because of changing demographics of American society. The traditional nuclear family with 2 parents and 2.5 children is becoming less common. Many times, people are choosing their families, and the concept of family is becoming much more fluid and much more flexible. Given these realities, these trends over the course of really several decades, strict adherence to traditional definitions of family is starting to seem irrational. At the same time, as further described in the paper, I describe how difficult it is for local governments to actually regulate whether a group is a functional family or not. So it is certainly difficult for local governments to deal with this issue, and I'll let you explore more in that paper. For now, I'll leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.